And I've got just my normal opening remarks for hearings. And it's our code of conduct. All public comment and testimony will be civil and respectful. Address the Board of County Commissioners and not the audience. Address issues and not persons. Refrain from applause as it interferes with due process. Do raise your hands if you are in agreement with the speaker. And that's that. So changes to the agenda. Okay, hearing none. Conflicts of interest?
None.
None. And now we'll go on to our one item, which is MSP 22-0004, Lakestone Estates reconsideration. And David, would you like to start us off, and maybe Pat?
I'll be glad to. Thank you. David Callahan, Community Development Director. We've had a request for reconsideration, and when that occurs, you must reconsider under the statutes, I mean. And so that's why we are here tonight. Vlad has 3 slides to show you, just to kind of remind you where we last were and what you last approved. But in my view, you basically have 3 options tonight. Assuming that you identify deficiencies in the decision that you last made, you could reconsider and change your decision to augment it, or alternatively decide that you were spot on and leave it as it was. And I'm just searching the statutes here, make sure. I thought there was a third thing here. Bear with me a second. Oh, so affirmed, reversed, or modified is what it comes down to. So there's really no applicant per se tonight. There's the reconsideration materials you've received, and then you can take whatever testimony that the audience wants to provide. You have your usual ability to limit with times.
Okay.
And with that, I would just ask that you let Vlad show whatever he wanted to show,
Okay.
if he did want to show anything. You can't get
This, this should be limited to an introduction of the case. The county will have its opportunity to argue its position after the people in favor of the reconsideration have spoken. And then after the county, the applicant will have the chance to speak, and I would request your indulgence in terms of the amount of time they use to make their case.
Okay. So intro to the case is staff, and then we're going to have our reconsideration group presentation.
Yep.
And then we'll have the county essentially kind of rebuttal, and then the applicant?
Yeah.
Okay.
And then, the applicant and anybody in support of the applicant's position besides the
Gotcha.
county.
Okay.
And then finally, the appellants get their chance to rebut.
Okay. All right. Oh, there you go, Vlad.
Commissioners, just wanted, for the record, Vlad Finkel with Kootenai County Community Development. The board on September 20th of this year signed order of decision approving a 24-lot major subdivision in Bayview. The slide shows the layout of the proposed major subdivision consisting of 24 residential lots and the interior road designed with access onto Perimeter Road and through Fur Road up onto Schaefer. I don't think there's much else I can add unless you have any questions specifically related to the overall design of the request.
Sorry, was that it?
Was that it?
Oh, okay. Great. Then I will call on Mike Lee, and we'll verify that all of the people are here to give Mr. Lee their time. So, Larry Lee, and David, if you could check on Zoom.
on Zoom.
Yeah.
Looks like we just have 2 people that are not staff on Zoom.
Okay. Can you give me the names of the two people?
Okay, I think you should be able to hear me now.
And who is this?
This is Mike Lee,
Okay.
Larry Lee, and I'm ready to go.
Okay, so Larry Lee is with you?
Yes.
You are Larry.
Oh, I am Larry Lee. This is I'm using Cheryl Puckett's computer, so
You said Mike.
yeah. Okay, Larry, Mike. It's always confused me my whole life. Trust me. Okay, here I go.
Well, no,
My-
I have to, sir, I have to verify that all the people are here in attendance who gave up their time for you to speak.
Oh, okay.
Yep. Okay, Susan Thompson in the audience or online? Okay. Ally, oh dear, I can read this name. Spaln? HN? Okay, is Ally here? Nope, Ally's not here. Gary Spahn? Gary's not here, okay. Margaret Nelson? Okay. And then Howard Bishop? Okay. Edith Bishop? Great. Frances Miller?
She's on Zoom.
Okay, great. And Alyssa McWilliams?
She's waving to you.
Oh, on Zoom too.
Oh, okay, we can't see Zoom, so, all right, so,
Commissioner Dumpson,
mhm.
there are people telling me that I got a text. They're stuck outside the building, and it's locked.
All right, we'll have staff.
Bob?
Staff is
Yeah.
heading that way.
Okay.
Judith Robinson and Michael Robinson. Okay, both here, great. And so, I'm sorry, Alyssa McWilliams is on Zoom?
I have Francie Miller.
Oh, okay, there we go. Okay. And then is it Chris Bodine? Chris? Okay. All right. Folks, are you part of the group presentation or you individual presenting? Individually. Okay, well, let me just call these names one more time then. Susan Thompson, Ally Spahn, Gary Spahn. Okay, Gary?
Yeah, Gary, my wife's gonna be on Zoom.
Okay, apparently she hasn't made it on Zoom yet. Okay, so I still have 8. Carl Blanchett? Carl on Zoom? Okay, finding that. So I am 1 short. You didn't sign up?
I signed, but I just said I may wish. Can I give my time tonight?
Yes. And what is your name?
Marie Streeter.
Okay. All right, so we've got everybody for Mike's time, and I'm sorry, was it, if it's a group presentation, but this is also the reconsideration, how many minutes is that?
Oh, it'd be the
Pat?
same.
So I have 10 applicants that gave up their name, or 10. I have 10 public who's given up their time for, but it's also the person who did the reconsideration. Okay, so is it 15 minutes?
Yeah,
Okay.
it'd be the same as any other.
Okay, perfect. All right, Mike or Larry, just give us another couple minutes while we get some people settled in the back. And then your 15
problem.
minutes will start. All right, we're ready, so go ahead.
Okay, thank you very much. My name is Mike Lee. I live at 16023 East Shaper Street in Bayview, Idaho. I represent not only the residents seeking to defend their property rights who have been forced to pay over $800 for this review of your decision, but the hundreds of local residents who support this appeal. In addition to this testimony and written submission, please also include all my previous testimony and documentation in this reconsideration. According to Idaho Code, we deserve a full and unbiased assessment of each and every detail of our appeal and the points of order we have addressed. Case in point, Ms. Duncan's and Mr. Matterly's entirely inadequate response to our appeal. Their findings that we have no standing and that they have no authority or responsibility to police the arbitrary decision-making process of the Lakes Highway District lacked substance and merit. Forcing a non-code required egress that routes traffic through our neighborhoods, then threatening administrative extortion by holding the developer hostage is just one aspect of Lakes Highway District's offensive public policy decisions. Regardless of the overwhelming evidence supporting our claim, you have failed to properly address any specific administrative or regulatory authority in your response to our plea for representation. We hear references to unsubstantiated rules, regulations, and judiciary precedents, but never specific evidence. Legal hearsay is not fulfilling your duty of care and loyalty. Neither is causing an emotional, financial, judicial, and social burden on the developer, taxpayers, and the plaintiffs by standing up for the negligent behavior of the Lakes Highway District and abdicating your authority to represent the interests of your constituents. Your duty to serve our civic safety and property rights is non-negotiable. Vague promises of remediation based on goodwill, when none has been granted, hold no merit. There is not a roadway in Bayview that meets proper transportation standards. Goodwill and public trust has not provided a single crosswalk nor other consideration for public transportation safety from Lakes Highway District in the past. The existing subdivision plan is sorely inadequate in addressing multimodal transportation needs, and Lakes Highway District is negligent in not identifying multiple existing traffic safety issues, not to mention numerous future liabilities. Incompetence negates administrative authority. It is your obligation to fulfill your duty of care and to stand up for our rights and fulfill your obligation to govern. Your fear-based claims of rulemaking, precedents, and lawsuits are baseless. Lectures on representative government without the courage to represent are hollow platitudes. Focusing on the rights of the subdivision over the rights of the community is insulting. Loss of confidence. The saddest loss, beyond the threat of lifestyle, property values, and public safety, is the loss of confidence in our elected officials. This sacred pact is the foundation of democracy. A failure of checks and balances. Your attempt to avoid responsibility for the well-being of your constituents represents a failure of the system of checks and balances. When branches of government seek to support and defend one another rather than embracing their administrative obligations to serve the public interest, our system of representative government has failed. Idaho taking law. Due to the fact that the proposed egress on Fur Avenue is not a code-mandated access and will result in the degradation of the quality of life, property values, and safety of the property owners adjacent to and surrounding Fur Avenue, this action by Lakes Highway District and your failure to hold them accountable amounts to a taking to defend and forces us to defend our property rights. To lead is to serve, your fiduciary obligation. No power is granted to you as individuals. Representatives are fiduciaries that must act to achieve the public good. As fiduciaries, while you cannot act beyond your legal authority, you cannot shirk your responsibility to act in service of your constituents' best interests. Lake Highway District's abuse of power by overstepping authority. The Planning Department only requires the Lakes Highway District to provide general comments and verify whether the surrounding road system will be adequate for the expected increase in traffic. General comments such as provide multimodal access, add a sidewalk, or extend the existing pedestrian shoulder and add a crosswalk to the post office would have been helpful and complied with their duty. Requiring an arbitrary and capricious non-code required egress that will result in the degradation of property values is an abuse of power. Holding the development hostage and using their authority to extort conformity from the Kootenai County Commissioners is a classic case of abuse of power. Failure to act on our behalf and curtail this behavior is your sin. Failures of Kootenai County planning. Regardless the claims of your planning department and Commissioner Duncan, the Lakestone Estates planning documentation is sorely inadequate in satisfying your own requirements and must be denied. In review of the subdivision rules, we question whether Lakestone Estates satisfies the regulations and request a review of each listed condition for accuracy and compliance. With over 20 examples of your regulations being open for interpretation at the very least, we didn't have time to discuss them all here. Here are a few examples. Please reference and respond to the entire list in our written transcript. You fail your constituents by not enforcing your own regulations that require the development to promote the health, safety, and general welfare of the citizens of Kootenai County and adequately addresses and mitigate any negative environmental, social, or economic impacts. You fail as well in ensuring that proposed roads, sidewalks, and trails establish or adequately contribute to a transportation system for vehicles, bicycles, pedestrians that is safe, efficient, and minimizes traffic congestion. The Lakestone Thoroughfare, utilizing Fir Avenue, does not in any way contribute to a safe and efficient route for pedestrians, bicycles, or even motor vehicles. Routing traffic onto a 15-foot wide side street is bad enough, but making no concessions for sidewalks, crosswalks, streetlights, or even signage represents an administrative negligence and ultimately exposes the county to liability. Failure to defend the public interest. You're tasked to protect and promote property rights and enhance property values. The plan fails to protect and promote property rights and enhance property values. Properly designated lots and open spaces. The proposal will create lots of reasonable utility and livability which are capable of being built upon without imposing an unreasonable burden on future owners. Areas not suited for development are to be designated as open spaces. The streamside buffer zone, therefore, needs to be excluded from the lots in designation and be designated as open space according to your rules. Lot number 1 appears unbuildable without encroaching on the stream buffer. Including the stream buffer as private property is a flaw that will place a future burden on owners, regulators, and our community. Failure to address our concerns in a substantive manner. The recommendations of the hearing body shall comply with Idaho code and shall cite the applicable legal standards, state the evidence and conclusions on which the decision was made, and explain any relevant contested facts and its evaluation of these facts. Our simple request for a gate, after partial approval, has been treated with condescendence at best. Excuses without legal standing and evidence are all, without legal standings or evidence are all we hear. You must deny the proposed Lakestone plan. If the proposal cannot meet one or more of these requirements, or if insufficient information was provided to make that determination, the hearing body shall recommend denial. You must deny this subdivision. David Callahan's flawed reasoning. Mr. Callahan's unsupported claim that this is a matter of law without providing the matter of law mimics the overly broad yet restrictive and unsubstantiated claims made by Lakes Highway District Attorney and your own legal counsel. This appears to be a case of administrative collusion and avoidance of responsibility. Please address this charge. To claim that our case has nothing to do with empirical data rests on denial of any objective standards of administrative responsibility and the rights of people who are sworn to represent. You are sworn to represent. The Lakes Highway District's authority does not extend to arbitrary and capricious decision-making in violation of code and best management practices. We have endured Lakes Highway District and now Kootenai County seeking to game and manipulate administrative, legislative, and governmental authority on the basis of rules either made up or vaguely interpreted. Debasing public trust, property rights, engineering standards, and safety is a glaring example of administrative negligence. Lakes Highway District does not have the authority to force approval of a non-code required rules for no good reason. Mr. Callahan seeks to diminish the authority of the commissioners. Unfortunately, he offers no evidence beyond taking Lakes Highway District at their word. This discounts the constitutional requirements of balances of power. Elected and appointed officials, especially when faced with overwhelming evidence to the contrary, do not have the right to endanger public safety and trust and to bear false witness to the facts. Your duty of service requires you to educate yourselves about the public trust issues you are tasked with upholding and defend your constituents' civil and property rights. In denial of your fiduciary duty of loyalty and care and disregarding the civil and property rights of your constituents, you are engaged in an abuse of power along with Lakes Highway District. It is your responsibility to fully comprehend and express the actual scope and duty of your position. A conflict of interests exists in the bias shown towards the developer that is clearly a violation of fiduciary duty on your part. There is a moral and ethical standard involved in legislative duties that requires you to err on the side of safety in regards to your constituents. We are not your wards. You are not our masters, but rather our servants. It is your sacred duty to serve us. Public service is a public trust. Honest public service means being conscientious, loyal, faithful, and unbiased. A fiduciary is a person with a position of control and influence over another person's rights, property, and finances. Public service fiduciary
Okay, sir.
obligations.
Your time is up. Can you just finish
Are
your
you
last
willing-
thought, please?
I will. You are tasked to serve with loyalty, placing the public's best interests first, with care, diligently acting with the utmost good faith, enacting policy serving the good of the governed, engaging in honest debate, assessing and monitoring public preferences, maintaining public trust in government, serving the public good, avoiding impropriety, exercising good stewardship, and acting with civility and respect towards your constituents. A duty to preserve good faith and trust. Being a fiduciary thus requires being bound both legally and ethically to act in the other's best interests. Please do your duty. Give us our gate. Thank you very much.
Thank you. Any questions for Mr. Lee?
Yeah, I'm curious. You made the comment that Lakes Highway District has been negligent. And I'm just curious how you see the BOCC's role in managing negligence from another entity.
You know, drive through Bayview and tell me that the transportation corridor is properly managed, especially during the summer when you have tourists looking for crosswalks. And tell me you don't have some authority to protect us from negligent behavior. You know, we're going to address all of this. And in my written testimony that Mr. Finkel seems to think I should have submitted a week ago rather than sending it in right now, I go into this in far greater detail. I'm not an attorney, but trust me, you will be facing an attorney because we are not going to stand for this. It's just outrageous. We're experiencing this growth on a percentage basis that is really unprecedented in Bayview. Our infrastructure is going to handle it, but is it going to handle it properly? And that is not a question we should have to deal with after the fact. We need to use your rules and regulations to properly make sure that these subdivisions that are coming all around us are properly developed and they're not able to avoid their responsibility to public safety and welfare. Like I say, I'm not an attorney. That's really not a fair question to ask. I mean, this is you guys' job. I'm so disgusted with having to do your job that it's like I'm really having to hold my tongue here. Sorry.
Now, Mr. Lee, I understand, but it was your comment, and that's what I was asking. How that can be bridged with the Board of County Commissioners fiduciary to oversee Lakes Highway District.
Well, I have a call into the organization, the Association of Lakes of Highway Districts in the state of Idaho, and maybe you could call them and talk to them as well. I really think this is your job. It's not my job. I'm forced to do this. I'm not getting paid to do this. It's extremely frustrating, and I'm doing my best to hold back the level of emotion and passion and anger that I actually have towards this whole process that I've been forced to endure and that all my community is being forced to endure.
Yeah. You made another comment of a failure of checks and balances, and I'm just curious as to, again, how you see the check and balance being with the Board of County Commissioners and the Lakes Highway District, which is what I presume you were referencing.
It's my understanding that the highway districts were actually empowered by the state, but formed by the county. And so there seems to me to be like a hierarchy of authority that comes from the master plan and all that other stuff, and that the Lakes Highway District is really just there to make sure that the proper protocol when it comes to engineering is followed. It's not that they're there to make policy and code, which is what they're trying to do. They're trying to usurp your authority by all appearances, and your whoever's giving you information about this is supporting them and not, like I said, looking at what the public good is here.
Yeah.
I am, these are questions that need to be asked, and I'm trying to ask these questions. I'm not the authority here, but I find I have to question the authority that's being represented.
Yeah, I understand, and I know some counties do actually manage highways. This county does not. They're completely separate and mutually exclusive districts.
Oh.
So there's zero. They don't have any. We don't have any primacy over them in any way, shape, or form.
Okay. So you don't have primacy over them in probably telling them what proper highway engineering would be. But when it comes to them not following your code and going beyond the pale in asserting their authority, I really don't see where you have any choice but to question that. And like I say, maybe this has to go to district court. That is really a sad statement of how government is working, and that's where we talk about balance of power and that kind of thing. Government entities should be able to, especially over a gate, be able to come to some terms of understanding. I have all the evidence in my package that shows that yes, they have all the authority in the world, including the authority to put up a gate, which is what they denied before. But they don't have the authority to override the code of the county. They don't have the authority to override, the state and federal regulations. They're not God. And I think that perhaps those commissioners have been in their positions so long that they get the feeling that they are like I say, the masters and not the servants.
Yeah.
And they need to be reminded of that, and that is your duty as our representatives to stand up for our rights, to question your staff and their decision-making process, Lakes Highway District, their decision-making process. It's your duty to stand up for our rights. And we're just asking you, you chose to represent us. Represent us.
I just have one other question, because you mentioned the crosswalks and street lighting before, and I just
Yeah.
want to know, were you referencing that within the subdivision or within Bayview itself?
Everything. So this subdivision, if you look, it's going to be the primary route for, say, 150 houses or something like that to get to the post office and the community center, to access the road north to Sandpoint, to access the public lands north of it. There's going to be all different kinds of traffic in all different ways and means possible going through that development. And the plan doesn't even include any way for those people to go through that subdivision without walking in the street. And then once they get to Perimeter Road, where people are in the process of accelerating and blasting their way out of town, they have to cross the street to the post office. They have to walk about, I would say, at least 100 feet on a narrow shoulder to get to the public walkway that goes down there. All these things should have been added to the plan. You know, when Lakes Highway District, that's why they were so negligent in this. They asked for something they had no right to ask for and that wasn't required by code. Yet they didn't include all the things they should have to ensure public safety, welfare, and things. Your code specifically addresses the fact that you are supposed to guarantee that these roadways have these multimodal transportation routes and are safe. And Lakes Highway District did not fulfill their obligation. And I can't imagine how you can believe that it's not your responsibility to stand up for our rights when this other agency is basically violating our rights.
This next question is not for you, Mr. Lee, but I'm just curious from staff, do we have code for roads or anything within
There are requirements in the code for certain that we have roads, but there's no requirement for multimodal roads per se.
or crosswalks or anything like that you're aware of?
Especially not outside of the subdivision.
Okay.
But you're right, there's not a requirement for sidewalks or crosswalks in the subdivision code.
Okay. All right, thank you.
Sure.
I have no future or further
Okay.
questions.
All right, then I will ask that, I'll just read the people who want to come up and speak. So Robert Prince, in favor of reconsideration, does not wish to speak. And David Anderson, in favor of reconsideration, does wish to speak.
Good evening. David Anderson, 16172 East 4th Street.
Oh, you got to hit the button on the,
Thank you. I appreciate it. David Anderson, 16172 East 4th Street, Bayview. A lot of technical stuff. I'm not going to get into all that. I'm just going to be here as a community member. Many of my neighbors. People have a right to do on their land what they want to do, but I don't believe that should change the community. Bayview's been a long history community. It's quiet. It's peaceful. I live there. I know what will happen when that road opens, and so does everyone in this room. We all drive around Idaho, been driving around Idaho for a long time, North Idaho. Look at the traffic. Look at what's happening in our community. How long will it be until all of Bayview is paved over and subdivided? Let's try to keep Bayview what it is. A small, quiet, historic community. It deserves it. My neighbors deserve it. You deserve it. To have a place to go to. You yourself said you'd been there, right? You've been to Bayview? Mm-hmm. It's a beautiful little community. It's a little old, it's a little run down, but it's quiet, it's peaceful. And it should stay that way. They have a right to build their houses. Let them build. But don't ruin my community because of it. Thank you.
Larry Dubay, is that right? In favor of reconsideration, wishes to speak.
Yeah, I also reside in Bayview, 33936 North Fir Avenue, which directly affects my home and my children, my grandchildren, and everything with the weather when they come. And I see no common sense by promoting this thoroughfare on First Street to get to a complex which is no longer really part of Bayview and the historic value of Bayview. I've been to every meeting that we've been to, and I keep being told that, they have ordinances. I have not seen any ordinances on roads and gates, cul-de-sacs, anything else other than they just want to go plow through First Street and let the people that reside in that town have the mess to deal with that. I've also done research myself on that. Find ordinances, have not found any ordinances regarding any of that I've been told that we're supposed to be taking everyone's word for. So I don't want a thoroughfare in my neighborhood. It's detrimental to all that live there in Bayview. None of the people that I've been in these meetings even reside in Bayview. So how do they even know what we're going to deal with, what we've been dealing with, and what we're going to deal with when if this road does get proposed, it does happen, okay? It's a direct threat to all people that walk, golf carts, four-wheelers, bicycles, kids playing in the streets. They've done it for years. Now, all of a sudden, we've got to sit back and let this thoroughfare thing happen at the detriment of our children and our grandchildren? I don't think so. So I propose, the gate would be okay too, but I propose a cul-de-sac. I've traveled on Howard Road off of Perimeter, and on Howard Road going to the Super One and going to 54. I've seen paved roads going off there. I've traveled on those paved roads. Every one of those paved roads that I went there had a cul-de-sac. There was not a thoroughfare through there. There was no in-out on it. It was a cul-de-sac where you come in, you turn around, you come back out. Okay? So yeah, I'm opposed to this thoroughfare on First Street, and I propose other alternatives, which I'm not seeing anybody practice or even mention to any of us that live there. So those are my concerns, and I hope you people will take that into consideration.
Thank you.
Thank you very much.
All right, anyone on Zoom in favor of the reconsideration who has not given up their time?
I would like to speak.
Your name?
Cheryl Puckett.
Okay.
It is the August 17, 2023 deliberations hearing that I would like to seek some clarifications and share additional insights based on the points raised during that discussion. Commissioner Mattery, you commented that the original plans for Fir Avenue, you stated there were always plans for opening this. Those were your words that evening. My understanding is that the initial plans involved a walk through open space, not a roadway connection. If there's different original plans, I would appreciate clarifications. Commissioner Mattery, you mentioned during the deliberations that there is judiciary precedence on gates on roads. could you kindly provide the specific statute or rule of law that supports this statement? You also, in reference to your suggestion, asking Lakes Highway District to modify the road, possibly by reducing the width and adding speed bumps, I'm curious about the feasibility of such requests. It seems like a reliance on the potential actions from a separate entity without clear commitments. Could you shed light on how we could be assured that these alterations will indeed take place? Lastly, you mentioned potential costly litigation as a reason for denying us. Is it from the Lakes Highway District, the developer, or another party? Clarifying this point would help us understand the perceived risks. Commissioner Duncan, I noted in your deliberations you mentioned the following. In over 5 years, you have been making land use decisions. You do not recall where the fear expressed at the meetings has come true. While I respect your experience, it is essential to consider various perspectives. Hopefully, you agree that self-validating subjective bias has no place in the administration process. Lastly, I want to bring to your attention something very interesting, that a gate was erected on Spruce Avenue, merely 1 block from Fir Avenue, by a local Bayview citizen. Lakes Highway District was aware of this gate for 5 years.
All right, thank you, ma'am.
Until
Your time is up. Thank you. Any questions for Ms. Puckett?
I mean, I wouldn't mind answering some of those things, but we can do that when the time is right.
Yep.
Yeah. Go ahead, or
Vlad?
I would like to add into the record that before the hearing, we did get a written submittal by the group presenter, Mr. Lee. I did advise Mr. Lee that we could not submit it into the record on our own. It would have to be Mr. Lee himself, which he did verbally over Zoom. But we do have an electronic copy of his testimony that perhaps we should add have an exhibit added to that testimony and enter it into the record.
And I would just reiterate, it should be entered into the record. And for the clerk's edification, this is the 4th hearing, so it should be marked as B 4000.
So that'll be B 4001.
Okay, 4001.
All right. Anybody else in favor of the reconsideration who has not spoken or given up their time? All right. And now it would be the county.
Commissioners, would you like to question staff on some of the points that were raised by the individual request and reconsideration, or what would you like staff to present in reference to our testimony?
Well, I can make our favor of our decision if you don't have anything to present.
I do not, unless the board wants clarification with regard to some of the questions that were raised.
And we can reserve time for questions of both staff and myself. I'm Pat Braden, Civil Deputy Prosecuting Attorney for the record. The decision of the board has been consistent throughout this process with one exception. That's having to do with whether there should be a gate or a one-way street at the south end of the development connecting to First Street at Schaefer Avenue. The most recent decision of this board was to allow a one-way street, which the highway district indicated it would be amenable to approving, when it would not be amenable to approving a gate because it actually violates state statute according to the interpretation of their attorney. And I have no reason to question that interpretation. I've read it myself, and I tend to concur with that analysis. With respect to the reconsideration, there really, although he has technically made points that are within the scope of reconsideration under state law, I have not heard any substantive argument that the order of decision did not meet the requirements of statute for being, with respect to specific approval standards or specific decision criteria. They were all considered. The decision criteria approval standards are very clear and very extensive in the county's subdivision ordinance, and they were applied in this board's order of decision. We've heard some very conclusory statements that that was not the case, but we have not heard any reasoning supporting that. Therefore, I would, and we also will have testimony from the applicant's representative, another attorney, who can possibly fill in some of the gaps that might come out in my testimony, my argument. But I would just state, one, the most recent decision of this board seems to be a sound compromise between people that wanted a gate and what the highway district was willing to approve. Again, with the suggestion that was in Commissioner Matari's motion that the highway district also potentially entertain other means to restrict traffic flow through the southern entrance/exit to the development. I think most of the argument was truly against the development itself and not so much against the whether there's a gate or a one-way road there. But of course, the focus is that gate, the gate versus the one-way road. So, because I believe that the decision was made upon substantial evidence in the record, did consider all of the necessary requirements for approval of the subdivision, and the board found that those were met, and also respected the separation of powers between the Board of County Commissioners and Lakes Highway District, and their autonomy and their authority to make those kinds of decisions with respect to roads. And accepting the compromise that the highway district was willing to offer, I believe that the most recent decision of this board should be affirmed. Are there any questions?
I have a question.
Yes.
A comment was made about, from Mr. Lee, about the buffer zone near
Yes.
the creek and whether that should be designated open space and it should not be part of the individual lots.
Well,
is there merit to that?
I don't know if they would actually meet minimum lot size if that was done. Regardless, because the designation of the buffer renders it open space, even though it may be part of a privately owned property. Mm-hmm. Even if it were designated as its own sort of outlot as open space, somebody would have to own it and somebody would have to be responsible for maintaining it. We've seen that in conservation design subdivisions. So I don't know that it's a distinction with any difference.
So the buffer zone just cannot be developed?
Correct.
Okay.
Any other questions?
No.
No.
Thank you.
Thank you. All right, then we will hear from the applicant or the applicant's representative, and then those in opposed of the reconsideration. I'm sorry? that. Is this 10 minutes or 15? I don't,
I would probably, is Ms., your, one of the applicant's representatives, Ms. Kruger? And Mr.
We may all speak a little bit, but we can do this.
Probably an aggregate of 15 minutes, I would say.
I think that would be fine. Just wanna, since the notes here. Well, the first statement that I would like to say is just to echo Mr. Braden, that is the applicant's representative. We do believe the most recent decision of the county commissioners was a proper and reasoned decision, and we felt that it took into account all of the regulatory requirements of the code, the agency powers, and a variety of other factors. And there was a lot of process that went into this, and we're very grateful to everyone for the work they put into this. I don't really want to rehash our entire presentation and everything that we've talked about, but I have some points here just as to, kind of a real quick synopsis of how we do meet the code. And so I'm just going to run through this a lot. I don't think a lot of this, or run through this quickly. I don't think a lot of it is in debate, and then hit on a couple of points that were made here today. We are in an area with restricted residential zoning. The minimum lot size is 8,250 square feet, and single-family residential, importantly, is a use of right in the zone district. We're also surrounded by other properties that are similarly zoned, and we actually have larger lot sizes than the minimum so that we can blend with the surrounding neighborhood. We're located in an area where we have other urban properties and we have services. We also have a collector road system and state highways around us and that we access. And we have low peak hour traffic accessing onto those roads. And that traffic impact has been evaluated by Lakes Highway District to the point that they have said that we do not need to have any traffic studies. And this is within their purview to do that. These roads are within right-of-ways that are designated and managed by Lakes Highway District, as is the road infrastructure within them. So they have very direct responsibility for that system, not only in terms of what's constructed, but also in terms of the traffic on it. We are in an area where we have school services, we have emergency response services, and if you look at all of the agencies who have commented, they have approved this or they have approved it with conditions. As you're aware, we've been working for several years on this project. We began our work, I believe, actually in late 2018 and worked for several years with Bayview Water and Sewer on this project. So we've been at it for a long time. And this year, as you know, has been the year of hearings, so we started working with the hearing examiner in January, and so we're finishing our work on this now. During that time, different things have come up. There was a request to look at riparian area protection, and we did tell the county, yes, press pause on our application and work this out. When the issues came up with connectivity, we also said, all right, we'll just kind of wait, we'll work with people. We made some connections with the highway district, and then the highway district, through communication with us and communication with staff, came back with this idea of one-way north-directed traffic as a way to work with the neighborhood and work with their needs, but also to satisfy their needs for connectivity. We've also agreed to, in this plat, additional riparian area protection. So there was just a discussion about that protection. And we do have a 75-foot buffer. We know that as they looked at the stream and they found fish species within it, that we expanded those stream protections. But additionally, over and above that, we agreed to something that isn't required, and that is that we agreed that over and above what is ordinarily allowed in a stream protection buffer, we agreed to treat our entire buffer almost as if it were a flood zone. And so we have protective measures where we actually can't do anything within that area. Whereas if this was strictly a critical area or stream buffer, there would be a moderate amount of activity that you can do within that area. So that was a voluntary thing that we did, recognizing and valuing that stream. I want to note that all of our utilities and roads will be extended at the cost of the owner. We will pay taxes and we will pay fees to mitigate any of our specific infrastructure and service impacts. I also want to note that this project has been approved twice now. It was first approved by the hearing, it was approved in 2007, and that time was for a 29-lot subdivision. And that was with a 30-foot stream protection buffer and with two-way traffic to the south on Fur Avenue. Our hearing examiner, John Woodward, recommended approval with conditions on January 27th of 2023, and the Kootenai County Commissioners approved this with conditions on September 20th of 2023. The county does have connectivity policy. The Highway District has connectivity policy. It's couched within paragraphs of text that address a variety of things. And as we know, policy is not always a one-size-fits-all solution. You can't craft something that will fit every single solution. But there's strong language within both about connectivity. We're not defending connectivity. We've been willing to go either way, but because it's a part of the discussion, I think it's important to note that codes are meant to apply to a variety of circumstances, and there is language within both on connectivity. As to the road standards, we do have a rural road standard. That rural road standard is adopted through the Associated Highway District standards, and there's not a requirement for a sidewalk within that. If there was a requirement for a sidewalk, we would have put that in our plans. And that has been reviewed, and as we're all aware, Lakes Highway District has commented on that. So to that fact, I think one of the important things to remember is that zoning and road standards and road policy and county code are all established using hearing processes similar to what we have here. And they're established to give us the rules of the road when we as developers come in to develop. And we follow them. And we've followed them in this case. And we, at this point in time, we are requesting that you uphold your decision that you've made. We believe it to be proper. I'll let Gordon and others go on.
Thank you. Connie covered most of it, but I want to touch base on the traffic. She touched on the engineering standards. They'll conform to the highway district requirements. We're constrained to do that. The traffic, we've submitted the traffic trip generations, which calculate the traffic from this subdivision. Even when Fur was considered as a two-way, the impact of this subdivision, the traffic from this subdivision on the areas to the south was less than 3 trips in the peak hour. With it being a one-way north, there would be no impact from this subdivision on the neighborhood to the south. Whether or not off-site traffic comes north is not a consideration of this subdivision. It's not an impact of this subdivision. There was a point made about the safety of access on a perimeter road. Just to remind the board that Lakes Highway District is requiring a left turn warrant study that will require us to evaluate that access for site visibility and storage for left turn and accel and decel lanes on perimeter. So that's covered. That's really all I have to add.
Chairwoman Duncan, Commissioner Matari, my name is Marcus Johnson of Ramsden, Marcus, Ely, and DeSmet. I'm here on behalf of the applicant. Recognizing that this board is well-versed in this project, I believe it's been in front of you half a dozen times at this point, I do feel that there are a few salient points to make for the board. The first being is that the burden has shifted since the last time that the applicant was in front of you on this project. It is now the opponents who are bringing this request for reconsideration that carry the burden to prove that your September 20th decision was wrong. We have heard a lot of conjecture and speculation, but we have not heard any evidence to actually show how or why that September 20 decision was wrong. They have simply failed to meet that burden. We heard Mr. Lee say on several occasions that this is not his job. Well, with all due respect, as the opposition group pursuing a motion for reconsideration, that is his job. He carries the burden to prove that this board's decision was wrong. That has not been done. I think it's important to direct the board to a couple points of authority talking to this relationship between the Board of County Commissioners and Lakes Highway District. I want to start by pointing the board to a portion of Idaho code that pertains to the Highway District's jurisdiction. Now, Idaho Code 50-1330 says this: in a county with highway districts, the Highway District Board of Commissioners in such a district shall have exclusive general supervisory authority over all public streets and public rights-of-way under their jurisdiction within their district. The key takeaway from that law is exclusive authority. Now, what the opposition group is asking for this board to do is ignore that and ignore what this county's practice has been since Lakes Highway District and the other 3 associated highway districts were incorporated in 1971. And what they're asking you to do is infringe on that exclusive authority of the Highway District. It has been common practice for this board or for county staff in this board to seek comment from Lakes Highway District or the other associated highway districts and incorporate those comments into planning decisions moving forward. And I proffer that what they're asking you to do is a dangerous precedent. Now, it's a dangerous precedent because what they're asking you to do is to serve as a gatekeeper, and a gatekeeper of whether or not these agency comments actually have any merit. And what this request is asking you has far broader implications than just Lakes Highway District. This will theoretically apply to every single agency or comment that the board or city or county staff receives in the near future. You will be tasked with determining whether or not the board sitting in a review authority knows more about roads than the highway districts, whether the board knows more about this state's water than IDWR and the Idaho Department of Environmental Quality. I proffer that the reason that the board in the county delegates that authority is because there are specific agencies that have more knowledge and power than we do. I think that is true for myself as an applicant and for this board. I mean, there are certain agencies that know more about what these standards are than the board. That is a reality. But what this is really asking the board to do is to serve in this gatekeeping authority, and what that opens this board up to is very arbitrary decisions. Arbitrary decisions as to whether or not Lakes Highway District's comment does have any merit, or whether it does not. Whether or not this application, you are going to adopt Lakes Highway District's recommendation and comment in this application, you are not going to. And in my opinion, if in the event that this board decides that Lakes Highway District comment does not apply to this application, and that the board's preference and the opposition's preference overrides it, in my opinion, that is arbitrary. And further, that sends a very dangerous message to the highway districts in which the county and the districts have historically maintained a very good and cordial relationship. What that message is that these highway districts are nothing more than a agency tasked with maintaining these roads and really has no say in what they look like or how they are designed. I don't think that is a message that this board wants to be sending. I've also heard on several scenarios the applicant referred to as a developer, and that this board is putting the developer's rights in front of the constituents. And I proffer to this board that that is not the case. What the applicant is in this scenario is a landowner, and a landowner in the great state of Idaho. And real property rights in Idaho matter. What we have not heard is that the applicant has not met every single requirement for subdivision approval. That has not been disputed at any level. This board recognized that, city staff recognized that, Lakes Highway District has recognized that fact. That is not at dispute. The applicant has met every requirement for subdivision approval. One important omission that I think we have not heard from in the opposition group today is how this one-way road does not work. There have been a lot of people saying that they want a gate and that they are still requesting this gate, but that fails to consider that the conditions of approval are asking for a northbound one-way road. At no point has there been any testimony that a northbound one-way road does not meet or satisfy the concerns of the opposition group. There cannot be southbound traffic on a one-way road, which would otherwise filter the traffic onto Fur Road. It moves the opposite direction. And I recognize I'm out of time, but I do want to address Commissioner Matari's comment about the setbacks for the stream buffer, if you would allow me to address that.
Sure.
You had asked about whether or not the stream protection buffer will be a standalone lot. It will not, but under condition 7.13 of the order of decision, that will be addressed as a non-developable or non-buildable portion, which will be restricted in the covenants, the CCNRs. So that will be addressed in the CCNRs, which will be submitted for approval prior to final plat approval.
Yeah, my comment was really affirming or trying to confirm what the appellant had made in his opening remarks about the buffer zone and the open space.
Understood.
Yeah.
Yeah. So yes, it will not be a separate lot, but it will be restricted to building through the CCNRs.
Sure.
Does the board have any questions for me before I step away?
No.
Thank you for your time.
All right, then I will call for public comment for anyone who is opposed to the reconsideration. Anyone on Zoom? Okay, then we can go to the reconsideration appellant or filing group for rebuttal. And Pat, 5 minutes, 10 minutes? We do these.
10.
10 minutes, perfect. Okay. All right. So, Mr. Lee, are you going to speak on behalf for the rebuttal?
I will. I do have some things I'd like to say, but if I have any time left over and anybody else has anything to say, I'd really appreciate them having that opportunity as well. Hello?
You can start your 10 minutes now.
Oh, okay, thank you. About the streamside buffer, he says they have a CCR, but the county code that says clearly that it's supposed to be separate designated area, not part and not CCR, and I just want you to, and so look across the creek and see what's happened on the other side by the landowner over there and how it's been reported over and over to the county that he mowed it. He's put junk boats there. He is now in the process of placing fill there, but the county does nothing about it whatsoever. And so now you're going to tell me some CCRs in this document are going to protect that stream side when you can't even do that, and your regulations clearly state that a subdivision can't place a burden onto the future owners of the land and everything else. This needs to be redrawn and needs to be done. He tried to say that there was no that I didn't show any areas where the code of subdivision regulations was not fulfilled. Well, maybe they told you that all of those regulations were fulfilled, but I gave you about a half a dozen or more examples where clearly they were not fulfilled. And trust me, there's over 20 aspects of the subdivision regulations that have not been honored. And I just find it impossible to imagine that when you look through all this information, you don't see that your staff has failed you and failed you terribly in making sure that this subdivision is properly done. It's like, and I love the part where Lakes Highway District has complete and utter total authority to do whatever they damn well please. But at the same time, they can't put up a gate. And I, in my supplementary documentation, I show evidence of where they do have the absolute right to control the flow of traffic in any way, shape, form, or fashion they choose, but within proper code-based stuff. They can't make up like, oh, we're going to have this extra egress, and it doesn't matter if it's not in code, you know. They have the right to follow all their rules and regulations, but they don't have the right to make up rules and regulations, which is what they're doing now. And they are literally extorting and holding hostage the developer. And if you don't think you're the gatekeeper, what are you? I mean, that's your job. You're our representative. You're the one who's supposed to stand up for us. You're the one who's supposed to monitor these other agencies so they don't abuse their power, which is what Lakes Highway District is doing. I know this. I have seen numerous boards be overthrown because of the lack of following the fiduciary responsibility. And it's just like, I don't want to have to end this conversation with see you in district court, but that looks like where it's going, because you got people advising you who are just pulling stuff out of the air and making stuff up. They're not giving you, it's like they say, oh, the Lakes Highway District has this authority, but they still haven't quoted a code for us, you know, that says they can't put a gate up there. And I have in my documentation quoted a code for you that says they can put a gate up there. Lakes Highway District's attorney is a piece of work. And we've dealt with her in Bayview before. She led our water and sewer district down a primrose path, the same way as this, that led to a district court and a loss that cost us a lot of money. And I really just encourage you to dig deep on this, to consult with the state agencies and find a resolution to this that is clearly based on facts and not just a bunch of stale rhetoric that we keep hearing over and over and over. I've made the case. I have quoted the code. Everybody else is just like saying opinions and not giving us, you know, I guess he did give us one that said they had the supervisor authority, but he just read one sentence of it. Read the whole thing. And, you know, I hate to tell you your job, but you ran for this office. And when you are on a board of commissioners, you have the duty to become informed. You have to become a traffic engineer, a planning and zoning expert. Okay, I'm done. Thank you very much for listening to us, and I don't envy you your job, and I hope I don't see you in court.
Okay, so there's 4 minutes left. Are you finished with your rebuttal?
Does anybody else have anything they'd like to say?
I don't know if that's.
I guess I'm going to let you go.
Mr. Lee, yeah, you're the representative for the rebuttal, so I'm not sure that we're going to go around the bend again. So if you are finished with your rebuttal, then I will.
Yeah, just like I say, there's a lot of information, and as far as I can see, you shouldn't trust all of the opinions that you're getting. So thank you very much.
All right. So then I would entertain a motion to go into deliberation.
I'd like to ask Pat a question. Pat, can you confirm that the Board of County Commissioners has no ability to control a highway district?
Yes. Excuse me. Give me just a second. I had already closed out of my. The first statute that addresses this is the one that my colleague, Mr. Oh God, I can't remember his last. Johnson. What's that? Johnson. Yeah, Mr. Johnson cited, which is Idaho Code Section 50-1330. And there's also authority within Title 40, Chapter 13 of the Idaho Code, which also specifically and very clearly designates basically plenary authority over roads within a highway district to the Board of Commissioners of the highway district, not the county. In fact, the statute is actually reads that if a highway district is created, all of the powers and duties related to roads and bridges and highways that the county would otherwise have are vested in the highway district. Because we have 4 highway districts that can cover the entire county in Kootenai County. Each of those highway districts within their districts have that authority. That was my reference to separation of powers earlier as well.
Mm-hmm. And does that include inside developments as well?
Yes, it does. The only exception to that in the statute is within cities that have functioning street departments.
Okay. And as far as the throughway between the neighborhood and this lot, that was characterized in one of the previous meetings that it was established quite some time ago because there is no landowner house on either side of where this proposed road is supposed to go through to the subdevelopment, where that homeowner is actually losing property. It's being taken through eminent domain or some other method for that road.
Going back to the email correspondence, there's actually an email from Eric Shanley, the Director of Highways for Lakes Highway District, to Cheryl Puckett, who spoke earlier, in which he stated that that right-of-way had been dedicated back in 1962 when the plat for that area was approved.
Yeah, so no one's given up no one's losing any land at this point for
No.
that road to be built.
That is correct.
And no one has been paying property taxes on that land.
Correct.
Who lives on either side of that.
It is highway district right-of-way within highway district jurisdiction.
Okay. Okay. Those are my questions.
Okay. Would you like to end public testimony, enter into deliberations?
Yeah. I move that we end public testimony and enter into deliberations for MSP 22-0004 Lakestone Estates reconsideration.
Second.
Commissioner Matari?
Aye.
Chair Duncan?
Aye. All right. Would you like to deliberate now or a date certain?
I'm happy to deliberate now.
Uh-uh.
I believe that this board unanimously voted to approve this before.
You and I did because Commissioner Brooks was also not present at the
Yeah.
last deliberation.
Yeah. First of all, the thoroughfare, if it was for a walking path, the right-of-way would be significantly smaller, I believe. Because I want to address some of these comments that were made before. With respect to the judicial rulings on the gates, I actually did do some research, and I found some case law. I don't have it with me, but from memory, I seem to recall, I believe it was the Idaho Supreme Court that even said a gate on a public road should not be allowed, even if it's left open, for fear that the driver, by passing through an open gate, could actually not go back the other way because the gate could possibly be locked, closed and locked when they returned. And that was one of the judicial reasons for not having a gate on a public road. And I did research that, and I couldn't find the statute, but I wasn't looking for that as much as just the judicial precedent for it. And I do remember that. My comment about a narrow road with speed bumps is one, it was a plead because we don't have the authority under the Board of County Commissioners to impose that. However, the gate was my idea initially to try to address some of the major concerns within the community. And that if the gate were, originally the throughway was required for emergency vehicles. And so to have a gate that was accessible to emergency vehicles only to pass through the neighborhood was how I recall that being discussed in one of the first hearings that we had sat through, that I had sat through. And with respect to the costly litigation, the point is that the board is responsible for the county treasury, and not that I have a concern of entering into litigation, but I have a concern of entering into litigation knowing that you don't have any legal standing per se. And I don't want the board to be engaged in arbitrary decisions that can't hold up to judicial scrutiny. And so if I'd made that comment, that would have been the rationale for making such a comment. With respect to some of the other comments, you know, Lakes Highway District being negligent, abuse of power, things like that, I didn't hear anything about how this board was being negligent, and I didn't hear anything about how this board was engaged in an abuse of power. The reality is that this board has no authority, legal in any way, to impose its will, its desires over the Lakes Highway District. There is none. And so I can't find where this board made a mistake, overlooked some piece of information that wasn't already presented. Even crosswalks, things like that, it just doesn't fall under the purview of this board. I completely agree with the community that the Lakes Highway District probably has not been as listening as well as they could have to the community. But I don't believe that this board didn't try to find a way to work with the community through the gate. Through the gate. And in fact, the Lakes Highway District did give a little bit and make it a one-way road. They
Folks, this is deliberations. It's not communication with the audience.
So,
Sir, please.
yeah, I looked through the information that was submitted, and I could not find any specific reference where this board failed in its previous decision. And so at this point, I cannot find a way where we made a mistake and would consider reversing it or even modifying it.
I would agree, and since my tenure in office, I have worked with community development to make sure that I have understood every single requirement for these types of decisions that we make. And so in my studies, I go through and I make sure that every box is checked and that we go, down the road. And I appreciated your desire to have the gate to try to mitigate some of the concerns through the neighborhood. But I've also been called many times, can you do anything about the school districts? Can you do anything about the library district? Can you do anything about the college? And it's like, no, as Board of County Commissioner, I have a sphere of influence and decision-making ability, and it does not include any other taxing district. So, I would agree that if we even wanted to do something different, it would not be allowed by law. And I would agree to not enter into arbitrary court action at this point. And so I too have not found where this board has made a mistake in their original decision. Is there a motion?
And it is true, by the way, that that this part of the country is very decentralized. And so there are many different jurisdictions, many different taxing districts that control different tiny elements within our community. And that's probably one of the more challenging things to really truly understand and internalize in this community compared to others. Because for many people that come from other communities, the county typically is the central authority. It's the overseeing authority within the jurisdiction. In here, that's not the case. So with respect to a motion, would it be to deny the reconsideration, uphold the original decision?
Yes. Both, either or.
Okay.
Yeah, I would say deny the request for reconsideration and affirm the decision of the board.
I move that we deny the request for reconsideration for MSP 22-0004 Lakestone Estates and affirm the previous decision by this board.
Second.
Commissioner Matari?
Aye.
Chair Duncan?
Aye. All right, with that, 7:35, meeting adjourned.
Goodbye.
Yeah, you all need to be replaced.